But today, the Supreme Court is sending us backwards in our efforts to protect families and prevent gun violence.
So this is a tool that's helped solve 50% of crime.
Wait. Did they have to delete 252 million records?
Who is eligible for a concealed carry permit? This is not an ordinary permit. This is a special use.
The Nonpartisan Government Accountability Office issues a report in June of 2016, Firearms data.
You don't even need a permit to carry a gun. You can go out and carry a gun, open carry a gun.
Ninth Circuit dissolves stay. All right, folks, buckle up for some good news on the Second Amendment front. The Ninth Circuit just did a flip on the California concealed carry ban, and it's like a breath of fresh air for gun enthusiasts across the state. So here's the lowdown. You know that pesky administrative stay hanging over our heads like a rain cloud? The one that gave the green light to SB 2, the concealed carry ban in California? Well, guess what? The Ninth Circuit just grabbed that stay, crumpled it up, and threw it out the window. What does this mean for all the concealed carry enthusiasts out there? It means you can dust off those holsters and get ready to legally pack heat again. Circuit's decision to dissolve the administrative stay is like a neon sign saying, "Concealed carry welcome here." Imagine this. Your concealed carry permit, and the freedom to tuck that firearm away without constantly looking over your shoulder. It's like having your cake and eating it too, right?
Do arm braces make firearms more powerful?
They do not. They do not.
But today, the Supreme Court is sending us backwards in our efforts to protect families and prevent gun violence.
The decision basically kicks SB 2 to the curb, allowing the good people of California to exercise their Second Amendment rights without unnecessary restrictions. Now let's break it down a bit. The Ninth Circuit, in a surprising twist, decided that enough was enough. They unraveled the bureaucratic red tape and said, no more ban on concealed carry. It's a win for gun owners, a win for common sense, and a win for those who believe in the right to bear arms. For those who have been anxiously watching the legal drama unfold, this is the plot twist we've been waiting for. The administrative stay, which was like a dark cloud looming over our concealed carry dreams, has dissipated. Poof! Gone. So, here's to the Ninth Circuit for stepping up and making a decision that makes sense. It's not every day we see a court ruling that aligns with the voices of the people who value their constitutional rights. In a nutshell, the administrative stay on SB 2 has been dissolved, and concealed carry is back on the menu in California. It's a victory for gun owners, a triumph for freedom, and a reminder that sometimes the good guys do finish first. So, go ahead, California, holster up and exercise those Second Amendment rights. The Ninth Circuit just gave you the green light. Emergency order. Hold on to your holsters, folks, because we've got some breaking news hot off the legal press. The Ninth Circuit just dropped an emergency order that's a game changer for all you concealed carry enthusiasts out there. The concealed carry ban, SB 2, had its own fan club among those who weren't exactly fans of Second Amendment rights. But guess what? The Ninth Circuit just walked into the room, slammed down an emergency order, and said, no more playing games. The emergency order isn't just any run-of-the-mill decision. It's a slam dunk against the defiance of the concealed carry ban. It's like the Ninth Circuit grabbed the remote control and hit pause on the whole SB 2 show. So, what was this defiance all about? Well, someone, somewhere, thought it was a brilliant idea to go against the tide and push for the implementation of SB 2.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
Everyone here understand that the brace does nothing to make the weapon any more dangerous.
The emergency order is a swift and decisive move that restores a sense of sanity to the concealed carry landscape in California. And what's the result? SB 2's implementation, which would have brought about a statewide concealed carry ban, has been tossed out the window like yesterday's news. The Ninth Circuit's emergency order is like a legal wrecking ball that just smashed through the barriers, letting the people exercise their Second Amendment rights without unnecessary restrictions. So, to all you concealed carry enthusiasts in California, here's the good news. The Ninth Circuit has spoken, and it's in favor of your right to bear arms. The emergency order is a beacon of hope, ensuring that the decision to defy concealed carry rights has been struck down, and the path is clear for lawful gun owners. Holster up, California. Your Second Amendment rights just got a powerful boost. Legal victory. Let's dive into the legal arena because there's been a seismic shift. The Supreme Court just dropped a 6-3 decision that's sending shockwaves through the world of concealed carry in California. Grab your legal dictionaries because we're about to dissect this victory for the Second Amendment. First things first, a 6-3 ruling is no small potatoes. It's not just a victory, it's a resounding win. The Supreme Court has spoken, and the impact is echoing across the nation. So what's all the fuss about? Well, it's about a case that's near and dear to every concealed carry enthusiast in California. The legal eagles at the Supreme Court were handed a concealed carry case, and they didn't just give it a passing glance. No, they dived deep into the legal abyss and emerged with a 6-3 ruling that's making waves. Now let's talk about the nitty-gritty.
So this is a tool that's helped solve 50% of crime
Oh,
gun
wait.
traces.
Did they have to delete 252 million records?
Does everyone understand what a concealed weapon means? That you have no forewarning.
This decision isn't just about the specifics of a case. It's about a broader principle, our cherished Second Amendment rights. The Supreme Court, with its majority ruling, has essentially laid down the law, pun intended, on how these rights apply, especially in the context of concealed carry. So what's the impact on gun enthusiasts and concealed carry aficionados in California? It's monumental. The legal victory is like a beacon of hope, shining a light on the right to bear arms. The ruling is a slap on the wrist for any attempts to curtail these rights, especially when it comes to carrying concealed. Think of it this way. The Supreme Court, in its wisdom, has set a precedent that speaks volumes. It's a legal compass pointing towards the protection of individual rights when it comes to carrying concealed weapons. The 6-3 decision is like a legal guardian angel for those who believe in the freedom to holster up responsibly. Now, let's break down the implications. This ruling isn't just a win on paper. It's a shield against any attempts to undermine the fundamental right to carry concealed. It sends a clear message to any state, including California, that restrictions must align with the principles set forth by the highest court in the land. SB 2 struck down again. In the latest twist, SB 2, the concealed carry ban, has been struck down once again, and it's like a legal whiplash that's leaving gun owners in California doing a happy dance. Here's the scoop in a nutshell. Picture the California concealed carry ban SB 2 like a pesky mosquito buzzing around. Well, guess what? The legal warriors have just swatted it down. Again. The recent turn of events is like a breath of fresh air for those who believe in their right to carry concealed. Now let's break it down. It wasn't smooth sailing for a while. SB 2 cast a dark shadow over the ability to holster up and legally carry concealed. But hold on to your hats, because the legal cavalry has ridden in, waving the banner of freedom, and struck down SB 2. Again. It's like the legal equivalent of a superhero saving the day, not once, but twice. The ongoing legal battles have been nothing short of a legal drama series. Courts, rulings, appeals, it's been a nail-biter for those keeping track. But here's the twist. The recent reversal of the ban is a game-changer. It's like the legal system hit the reset button saying, "Hold up, SB 2, you're not welcome here." The reversal is a victory for gun owners who've been itching to exercise their Second Amendment rights without the unnecessary shackles of SB 2. It's a win for those who believe in the responsible and lawful right to carry concealed. The legal battles have been tough, but the recent update is a reminder that persistence pays off. Significant news for gun owners. The Ninth Circuit just made a decision that's sending shockwaves through the state. Concealed carry is legal again, and it's a victory worth celebrating. Let's break it down. The significance of the Ninth Circuit's decision cannot be overstated. It's not just a legal maneuver. It's a green light for gun owners and concealed carry permit holders. Imagine the weight lifted off your shoulders as you realize that the right to bear arms responsibly has been restored.
From Duke mentioned was that there were some 1,500 Second Amendment cases brought since the Heller decision.
You don't even need a permit to carry a gun. You can go out and carry a gun, open carry a gun.
The decision is like unlocking a door that was temporarily bolted shut, allowing gun owners to exercise their Second Amendment rights without unnecessary hindrance. Consider the concealed carry permit holders who felt their rights slipping away with the implementation of SB 2. Now they can holster up without constantly checking over their shoulders. It's a victory lap for those who believe in responsible gun ownership and the right to protect themselves and their families. The Ninth Circuit's decision is a beacon of hope for those who cherish their Second Amendment rights. It's a reminder that despite the legal twists and turns, the courts are recognizing the importance of preserving individual freedoms. So, California gun owners, dust off those holsters, because concealed carry is back on the table. It's time to celebrate the significance of this decision and the impact it has on the lives of those who value their right to bear arms responsibly. The Ninth Circuit just handed you back the keys to exercising your Second Amendment rights, and that's news worth raising a toast to. Holster up, California. Freedom to carry concealed is once again in your hands. Merit Panel Decision. All right, let's dive into the legal jargon and unravel the mysteries of the Ninth Circuit's Merit Panel decision that just shook up the landscape of concealed carry in California. Get ready for the lowdown on how this decision turned the tables on SB 2 restrictions. First off, what's this Merit Panel decision all about? It's like the judiciary's A-Team, a group of legal heavyweights who rolled up their sleeves and took a deep dive into the concealed carry ban saga. Picture them as the referees of the legal arena, making a call that's bound to have a ripple effect. So what did they decide? Brace yourselves, because the Ninth Circuit's Merit Panel played the hero's role and overturned the restrictions imposed by SB 2. That's right. They basically looked at the restrictions and said, "Not on our watch."
The Nonpartisan Government Accountability Office issues a report in June of 2016, Firearms Data.
And I would like to point out to the Supreme Court justices that the only weapons at the time were muskets.
Now let's break it down a bit more. The Merit Panel's decision isn't just a casual nod in passing. It's a deliberate move that sends a clear message. It's like they put on their legal superhero capes and decided the restrictions imposed by SB 2 were a no-go. They peeled away the layers and got to the heart of the matter, recognizing that individual rights needed protection. And what's the impact? It's colossal. The Ninth Circuit's Merit Panel decision is a lifeline thrown to those who felt the squeeze of SB 2's restrictions. It's like opening a door that was slammed shut, allowing the residents of California to exercise their right to concealed carry without unnecessary hindrances. Let's talk about the court's stance. The Ninth Circuit isn't playing a passive role here. Their decision to overturn SB 2 restrictions is a stance, a clear, unambiguous stance in favor of individual rights and responsible gun ownership. It's a legal declaration that the courts are standing up for the principles enshrined in the Second Amendment. May versus Bonta and FPC lawsuits. All right, grab a comfy seat and get ready for a legal roller coaster ride, because the May versus Bonta and FPC lawsuits have been weaving through the courts with twists and turns that rival a courtroom drama. Buckle up as we delve into the latest developments, their consolidation, and what the future may hold in this legal saga. To set the stage, the May versus Bonta case and the Firearms Policy Coalition lawsuit were already causing ripples in the legal landscape concerning concealed carry in California. These lawsuits were like legal warriors standing up against the restrictions imposed by SB 2, the concealed carry ban. Each case had its own story, its own arguments, and its own group of fighters for the right to bear arms. Now, let's fast forward to the latest scoop, the consolidation of these lawsuits. Yep, you heard it right. The legal bigwigs decided to bring May versus Bonta and the FPC lawsuit under the same legal roof. Why? Well, consolidation is like bringing together two powerful forces to create an even stronger legal entity. It streamlines the legal proceedings, avoids duplications, and presents a united front against the common foe, the concealed carry ban. This consolidation is significant. It's not just a paperwork shuffle, it's a strategic move that combines the strengths of both lawsuits into a legal powerhouse. May versus Bonta, where individuals like Mr. May were standing up for their concealed carry rights, and the FPC lawsuit, driven by an organization dedicated to defending the Second Amendment, have joined forces. Now, let's peek behind the legal curtain and explore what's been happening in these consolidated cases.
So while the Supreme Court has not made a ruling in this case, it indicated Tuesday.
Why do we have guns? Why do we have the Second Amendment?
One key player in this legal drama has been the Ninth Circuit. They're the referees in this match, and their decisions have been shaping the battlefield. The legal chessboard saw a consolidation motion granted, bringing the May v. Bonta and FPC cases together for a combined legal attack. It's a move that echoes the saying, "United we stand, divided we fall." What can we expect in the future? That's the million-dollar question. The consolidated cases are now headed to a merits panel, a high-stakes legal showdown where the arguments will be put to the test. The cases are calendared for argument in April, and that's when the legal gladiators will present their best swords for the fight. The outcome is uncertain, and the legal landscape can shift like sand in the wind. But what we do know is that this legal battle has become a beacon of hope for those who believe in the right to concealed carry. The preliminary victories, the consolidation, the upcoming merits panel, it all adds up to a legal narrative that holds the promise of protecting individual rights in the face of restrictive laws. In the May v. Bonta and FPC lawsuits, we're witnessing a legal symphony where individual plaintiffs, organizations like the Firearms Policy Coalition, and the courts themselves play distinct roles. The outcome of this symphony will resonate not just in the courtrooms, but in the lives of those who value their right to bear arms responsibly. So, as we anticipate the next legal crescendo in April, one thing is clear. The May v. Bonta and FPC lawsuits have become emblematic battles in the broader fight for the Second Amendment. It's a saga worth watching, and it's a reminder that the legal system, like any great drama, has the power to shape the future for those who seek justice and defend their constitutional rights. Stay tuned, legal eagles and advocates alike, because the story is far from over. Injunction back in effect. Concealed carry permit holders have been in a bit of a bind lately, courtesy of SB 2, the concealed carry ban. It was like the rug was pulled out from under their feet, and the legal landscape became a bit uncertain. But guess what? The legal guardians, in the form of an injunction, have stepped in and said, "Not on our watch." Now, what does this mean for those who have been anxiously checking their holsters? It's a game changer. The reinstated injunction is like a legal safety net, catching all those who found their concealed carry rights hanging by a thread. Imagine the collective exhale of relief as the news spreads. Your right to carry concealed is no longer on shaky ground. The impact is immediate and it's personal. For individuals affected by SB 2, the reinstated injunction means they can once again holster up without the constant worry of legal repercussions.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
I would suggest that they need not to be in the presence of a firearm.
It's a return to the status quo that existed before the concealed carry ban threatened to strip away the freedom to carry responsibly. Think about the scenarios where SB 2 has cast a shadow, walking down the street, going about daily business, or even protecting oneself and loved ones. For concealed carry permit holders, SB 2 had created unnecessary hurdles and limitations. Now, with the injunction back in the game, those hurdles are being dismantled and the limitations lifted. It's not just about the legal technicalities, it's about the tangible impact on everyday lives. The reinstated injunction sends a clear message that the courts are attentive to the concerns of concealed carry permit holders. So to all you concealed carry permit holders in California, take a moment to savor this victory. The injunction is your legal shield and it's back in place. It's time to holster up with confidence, knowing that the legal landscape has tilted in your favor once again. The immediate impact is a sense of liberation for those who felt the weight of SB 2 on their shoulders. From administrative stay to dissolution. In the early days of 2024, the legal landscape for concealed carry permit holders in California took an unexpected turn as an administrative stay was imposed by the Ninth Circuit. This stay allowed Senate Bill 2, the concealed carry ban, to go into effect, leaving permit holders without the legal ability to carry concealed firearms, even with valid permits. The imposition of the administrative stay set the stage for a complex legal battle that would unfold over the coming months. Facing this restrictive administrative stay, attorneys representing gun owners, including those from Michel and Associates and the Firearms Policy Coalition, swiftly moved into action. Their primary goal was to challenge the administrative stay imposed by the Ninth Circuit, seeking its dissolution and a return to the pre-SB2 legal landscape. The legal warriors aimed to clarify the court's intent and pave the way for concealed carry permit holders to regain their rights. As the legal challenges mounted, the Ninth Circuit's motions panel granted an emergency motion, allowing SB2 to remain in effect temporarily. This decision, made on January 6, 2024, added to the uncertainty surrounding the concealed carry ban. Meanwhile, county sheriffs expressed reservations about enforcing SB2, further complicating the situation and raising questions about the practical implications of the ban. In late January 2024, a strategic move unfolded in the legal arena. The May v. Bonta case and the Firearms Policy Coalition lawsuit were consolidated. This consolidation aimed to create a more unified and potent legal challenge against the concealed carry ban. The legal battlefield saw a consolidation of forces, setting the stage for a more coordinated effort to combat the restrictions imposed by SB2.
We allow criminals to have firearms, then we're at risk.
It would uphold a federal law that bans people with protective orders against them from owning a gun.
Before the administrative stay, a significant victory was secured when Judge Cormac Carney granted a preliminary injunction against certain aspects of SB2 on December 30, 2023. However, the state of California promptly appealed this decision, seeking an emergency stay to override the preliminary injunction. The legal seesaw continued, with wins and setbacks shaping the overall trajectory of the concealed carry battle. The awaited turning point came with the dissolution of the administrative stay by the Ninth Circuit's merits panel. This decision, likely a result of persistent legal efforts, meant a return to the pre-SB2 status quo. The preliminary injunction granted by Judge Cormac Carney was reinstated, once again allowing concealed carry permit holders to exercise their rights more freely in California. As of the latest update, the consolidated cases are headed to a merits panel scheduled for argument in April. The legal saga continues, and the courts remain a pivotal arena for the ongoing struggle against restrictive concealed carry measures in California. The dissolution of the administrative stay marks a significant moment in this narrative, offering a renewed sense of hope for those who value their right to bear arms responsibly. Spread the word. First things first, grab your megaphones, social media accounts, and shout it from the rooftops. SB2, the concealed carry ban, has been dealt a blow, and it's time for concealed carry permit holders to rejoice. But why stop there? Let's make sure this news echoes through every corner of the state. Why does it matter? Well, for those who've been feeling the weight of SB2 on their shoulders, this is a game changer. It means the legal hoops and hurdles are being dismantled, and the right to carry concealed is back in action. It's not just about legal technicalities. It's about freedom, responsibility, and the right to protect oneself and loved ones. So, here's the call to action. Share the news. Hit that share button, send out a tweet, write a post, heck, even start a conversation with your neighbor. Let your fellow concealed carry permit holders know that the legal landscape just shifted and it's in their favor.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms."
Historical tradition of limiting Second Amendment rights when someone could pose a danger to society.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
Why the urgency? Legal battles can be like shifting sands. What's true today might change tomorrow. Staying informed is the key, and that starts with spreading the word. Imagine the collective power of an informed community. It's like creating a network of legal watchdogs, ensuring that everyone is in the loop and ready to defend their rights. And hey, let's not forget the importance of supporting those organizations that have been on the front lines fighting against these restrictive laws. consider throwing some support their way, whether it's a donation or a simple shout-out. Organizations like FPC, GOA, and CRPA have been in the trenches, and they deserve a nod for their hard work. So, California, let's make some noise. Share, shout, and let everyone know that SB2's reign is over. At least for now. It's a victory worth celebrating, and it's a testament to the resilience of those who believe in responsible gun ownership. That's all for this video, folks. Thanks so much for watching, and we'll see you the next time.